rise if able.
In the Court of Appeal Criminal Division, the King against Natasha, Akhtar, Ameer Jamal, Sanaf, Gulammustafa and Ansreen Bukhari. Are you Natasha?
Gentlemen, if it was all right with you all, we've obviously got the application in respect of sentence of Ansreen Bukhari, and we thought, Mr. Millington, we might deal with that first of all.
I'd be very grateful, my lord, if that's the case.
Really for your convenience as much as anything, if nobody else minds, and then we'll deal with the other matters after
I gather
that.
that Mr. Samat is going to respond to these applications.
Thank you very much, Mr. Samat. All right. Yes.
Well, there are, in fact, two applications
There are.
before the court.
Yeah.
One in relation to extension of time, and the second an application for leave also in relation to sentence.
It's all been referred, I think, hasn't it?
It has.
Yes.
In relation to extension of time, it's clear that there has been inordinate delay here. The original sentence was passed in September 2023. Following conviction and sentence, an application for leave to appeal conviction was made on behalf of Ansreen Bukhari, but there was no application in relation to sentence passed. Indeed, there was no professional support for such an application. The trial judge had found that there was no mitigation available to Ansreen Bukhari in relation to the background of blackmail and coercion, which was suggested to have been behaviour to which she had been subjected by one of the deceased, Saqib, in the weeks and on the day preceding the offences. That aspect of the case was a matter taken up by her daughter and co-accused, Mahek Bukhari, who had made application not just in relation to conviction, but also in relation to sentence. And that application in relation to sentence was heard here in the Court of Appeal, and judgment was handed down in October of last year. And essentially the Court of Appeal found that that mitigation was not available to Mahek Bukhari for various reasons, the court pointing out that she had not been the target of that behaviour in any event. That's not the case in relation to this application, because you have before you the target of that behaviour, which we would wish to argue the trial judge wrongly failed to take into account. And so for those reasons, and notwithstanding the very lengthy delay...
When you say he didn't take into account, he obviously did take into account. It's really whether or not he should give any, and if so, what type of allowance for that in
Well, that's correct, although he did mention the mitigation, but from a reading of the short sentencing remarks, appears to have dismissed it on the footing that Ansreen Bukhari shouldn't have approached the matter in the way that she did.
Yeah.
And he didn't purport to say in his sentencing remarks that he had allowed any reduction of the minimum term to take account of that feature of the case. So we would submit that it is appropriate to conclude that it has not in fact been taken into account in the fixing of the minimum term. There's very little more that I can say about the application for extension of time here. All that we do say is that it would be just and appropriate and in the interests of justice at this stage that these matters should be urged on behalf of Ansreen Bukhari, notwithstanding the inordinate delay.
Yes.
So shall I move on to...
I think you ought to, because I suspect the answer to both will be the same, won't it? If there's merit in the ground, no doubt the court is likely to give you an extension of time. If there isn't, there's little point.
I've been cautious in acknowledging that the inordinate delay in itself is a matter that doesn't help the applicant.
No. Well, we understand that's good of you, but I think for all our sakes that we will continue to listen to the application.
Then the merits. What we are saying here about this case is that having determined that she wanted to end the relationship, telling the deceased that she wanted to end it on good terms, the answer to that was plainly no. And thereafter, and over a period of many, many weeks leading up to these offences, there was what we would categorise as a relentless campaign of blackmail and coercive behaviour by him towards Ansreen Bukhari. And at the time that he was doing so, and unbeknown for some time to those involved in this case, a similar complaint had been made by another woman unconnected with the investigation of behaviour which called for her to make a report to the police, which she wanted to be dealt with on a sort of low-profile basis. Now, after many, many weeks of really quite overwhelming, unwelcome contact from Saqib, which included many, many different types of threat, including that he would come to the family home with mates, she sent him messages indicating that if he persisted, she would report the matters to the police. His response to that, which I've set out in our documents, was plainly intended by him to deter her from going to the police. And in that, he clearly succeeded. But the relentless and abusive messages and phone calls continued. And on the day of the offences, the tension had been significantly ramped up by Saqib towards Ansreen Bukhari, because he had determined that this was the day when he would carry out his threat to travel to the family home in Stoke and confront her and the family, and at the very least to show to her husband and members of the family the sexually compromising material that he possessed, and face the consequences of all of that. And so it was that she left the family home in company with her daughter, who she had, as the trial judge said, put in charge of the issue with calamitous, as the trial judge indicated, consequences, because by that time there was a plan in existence to seek to recover the messages from his phone and to inflict a beating upon him. And we submit that Ansreen Bukhari got sucked into that. And apart from the question of the mitigating effect of the blackmail and coercive behaviour, I've set out in the documents the other factors which we say have a profound bearing upon the determination of the length of the minimum term.
These are the 7 matters that you
They are.
mentioned. Yeah.
And in particular, the fact that she was not regarded as being one of the prime movers in this by the trial judge.
He made that point specifically, didn't he?
He did.
Yeah.
And I've quoted in my document the very few remarks that the co-accused who was acquitted made about Ansreen Bukhari when he was cross-examined by her then counsel, and I've spoken to Mr. Upwood about this appeal generally some considerable time ago, so that he is aware that I'm appearing to pursue this application today. I'm going to repeat myself if I say very much more about this. The Court of Appeal, in my respectful submission, clearly left open the question as to whether a background such as this can provide mitigation and the extent to which it ought to be taken into account, pointing out in rejecting it as a proposition canvassed on behalf of the daughter on the footing that she was plainly not the target. The relevance of the coercive behaviour has to do with the determination of Saqib to have contact with this woman, notwithstanding her threat to go to the police, and it was that unlawful behaviour which caused them to depart in pursuance of the plan that had been spoken to by her daughter. And the fact that there was very considerable mitigation allowed by the Court of Appeal by reason of the daughter's immaturity and youth, albeit that that's plainly not available to Ansreen, causes the submission to be made that the prime mover, as the judge found that she was, had a minimum term fixed which was much too high. The bar was set much too high, we submit.
And that was reduced, I think, to effectively 28 years, wasn't it? Yeah.
The mitigating effect, if the court finds there was such, from the coercive and controlling behaviour of Saqib has been set out now in statutory form. But it wasn't actually statutory mitigation at the time of the sentence. It became so, I believe, on the 29th of February 2024. And so, in statute, there is the potential for praying in aid that type of behaviour as mitigation sufficient to reduce the minimum term. And we submit that that hasn't happened in favour of Ansreen Bukhari in this case. And so we do very much pray now the fact that there is now statutory guidance on the relevance of coercive and controlling behaviour. And that is how we characterise the behaviour of Saqib towards Ansreen Bukhari.
Now you mentioned that provision, with this, if it was a more recent offence being dealt with now, would it also fall foul of one of the new aggravating factors as well? Because it's murder connected with the end of the offender's intimate personal relationship with the victim. It's not relevant for these purposes, but you mentioned the fact that it's mitigating. I wonder whether that will be, in fact, an aggravating factor now.
It might be, in different circumstances.
Or even these circumstances.
Yes, but all of the unlawful behaviour, apart from, of course, mention of a beating being administered, all of the unlawful behaviour was behaviour flowing from the victim here of the offences towards the defendant. And it wasn't transient. This was a campaign of behaviour that went on from about January, leading up to the commission of these grave offences. And we submit, given the control that he also attempted to exercise over another woman, demonstrates the potential difficulties that she had in dealing with it and bringing an end, which he didn't want, to this relationship in lawful and amiable terms. And that's the way we put it.
That's very clear. Thank you, Mr. Millington. Yes.
Well, I didn't, in the response notice, address the point that my Lord, you raised with my learned friend, because, of course, whilst he raises the question of coercive controlling behaviour, there is, in fact, of course, subsequent to the, not available under the old sentencing regime, but under the new sentencing regime, is, of course, under Schedule 21 of the Sentencing Act, subsection 9, the precise point that coming to the end of a relationship in such a situation can be an aggravating feature. And to that extent, I also...
I only raised it because, obviously, Mr. Millington raised the fact that it has now been amended so far as mitigation, but
exactly.
I think
but in this case, my Lord, the learned judge was well placed. I've set out fully in the response notice, well placed to assess the behaviour of the deceased Saqib Hussain towards the defendant in this case, or the appellant in this case, Ansreen Bukhari. And he had it well in mind. I've set out the areas within the sentencing remarks where he clearly did have those things in mind. The issue is whether or not, in fact, that gives any, affords any further mitigation down from the starting point, which is not criticised. The starting point having been set at 30 years because this was a murder of two people, or murders of two people. There being no dispute about that, the question is to what level does it mitigate or aggravate in this case. In my submission, the learned judge spoke mostly of going downwards in this case.
well, and indeed ended up significantly down from the starting point. Yeah.
If the point is being made as to the fact that the appellant Mahek Bukhari from the earlier decision, her sentence is too close, if you like, and effectively a disparity point, that doesn't arise because, of course, my learned friend's already identified the fact that different considerations apply to each.
Well, she was not only she's not only younger, but the judge specifically found, albeit this court considered he hadn't given enough weight to it, that she was immature for her age.
Indeed. Yeah. A point that I wish to raise in response to my learned friend's submissions is the suggestion that there is something in the fact that the deceased Saqib Hussain was subject of some police investigation, which of course didn't transpire. He wasn't interviewed about it, and in relation to the Thames Valley incident. In my submission, that can have no impact on the sentence in this case.
I don't think that is something that...
But overall, dealing with each of the 7 points, I've set out the Crown's response in relation to those in the respondent's notice. I noticed, in fact, an error in my numbering, because I did not include in the response a response to number 5 of the suggested reasons for that the lost my learned friend's
mobile phone.
Yes, the mobile phone. She did in fact provide. So there's number 5 should in fact read number 6 in my numbering on page 4 and 5 of the respondent's notice. In terms of being a prime mover, I deal with it like this, that so far as the Crown's case was concerned, she wasn't the prime mover in the murders, but she was an essential part of it. She was the reason for it, and she was also aware of the plans to lure the deceased Saqib Hussain to Leicester in the first place. There may well have been these messages passing backwards and forwards between the deceased Saqib Hussain and Mahek Bukhari. But the plan effectively was to lure him. That plan existed long before there was the exchanges or hostile exchanges between him and Mahek Bukhari. In fact, I think I make the point that in fact, even on the evening of the 9th of February, the day of the murders or the day before the murders, there is unchallenged evidence in the form of Sanaf Hussain, the deceased sister, Saqib's sister, in which she overheard a conversation between her brother, the deceased Saqib, and the applicant in this case, to the effect that he was told, effectively, and so she was central to the plan of getting Saqib to Leicester, that if he wanted his money, this was the money that Saqib had expended on the applicant during the course of their relationship, that he had to come and collect it from a boy in Leicester. And so without that, Saqib wouldn't have been in Leicester. And without that lure of the money and the return of that. In relation to my learned friend's submission in relation to the evidence of Mohammed Patel, he was kind enough this morning to provide me with the relevant sections. They are as he set out. However, it's clear that the learned judge considered that quite clearly and said in his sentencing remarks that I'm satisfied that the dialogue on the open phone line which existed between the two chasing cars, that the conversation about ramming the vehicle must have been heard by, and if not contributed to, by the occupants of both the Seat and the Audi. Well, I'm not sure there's much else I can say. I've set out fully in writing the Crown's observations. The learned judge, we say, did not fall into error in setting the starting point. He properly allowed matters in mitigation for her, namely that she wasn't a prime mover, and some of the other matters as well. But of course there was also some aggravation here as well, so there's a fine balance to be struck. The argument here, if it's disparity, would be whether or not somebody looking at this from the outside would say the judge got this wrong, or there's something seriously wrong. In my respectful submission, nobody would say that.
Thank you very much, Mr. Sanaf. Mr. Millington?
No, I'm not going to respond to that. I don't agree with it, but I've got nothing to add to what I said previously.
All right. Thank you very much, Mr. Millington. Well, we'll rise and consider those submissions. Thank you. On the 4th of August 2023, following a trial in the Crown Court at Leicester, Ansreen Bukhari, the applicant, was convicted of 2 counts of murder. Co-accused Rajiv Jamal, Rakan Karwan, Mahek Bukhari were also convicted of 2 counts of murder, whilst Ameer Jamal, Sanaf, Gulammustafa and Natasha Akhtar were acquitted of murder, but convicted of 2 alternative counts of manslaughter. Mohammed Patel was acquitted of both murder and manslaughter. On the 1st of September 2023, the trial judge sentenced the applicant and her co-accused as follows. The applicant, life imprisonment with a minimum term of 26 years and 9 months, based upon a minimum term of 27 years, less 3 months spent on qualifying curfew. Rajiv Jamal, life imprisonment with a minimum term of 36 years, based upon a minimum term of 31 years, increased to 36 years to take into account the unexpired term of a previous sentence for rape. Rekan Kawan, life imprisonment with a minimum term of 26 years and 10 months, based upon a minimum term of 27 years, less 2 months spent on qualifying curfew. Mahek Bukhari, life imprisonment with a minimum term of 31 years and 8 months, based upon a minimum term of 32 years, less 4 months spent on a qualifying curfew. Ameer Jamal, 15 years imprisonment. Sanaf, Gulammustafa, 15 years imprisonment. And Natasha Akhtar, 12 years imprisonment. Now, on the 24th of October 2025, this court allowed an appeal against the sentence imposed upon Mahek Bukhari, 2025 EWCA Crim 1353, by reducing her minimum term to 26 years and 285 days, based upon a minimum term of 28 years, less 4 months spent on a qualifying curfew, and 332 days on remand in custody. The applicant's application for an extension of time, 780 days, in which to apply for leave to appeal against her sentence, has been referred by the registrar to the full court. The offences. The details of the offences are succinctly set out between paragraphs 5 and 9 of the previous judgment of the court relating to Mahek Bukhari's appeal against sentence, and we gratefully adopt them for the purpose of dealing with this appeal application. The 2 deceased, Saqib, Hussain, and Hashim, Ijazuddin, died in a car crash in the early hours of the 11th of February 2022. They were travelling in a Skoda car along the A46 dual carriageway. Hashim was driving with Saqib in the passenger seat. At about 1:28 a.m., Saqib made a 999 call. The transcript includes him saying, quotes, "I'm being followed by 2 vehicles. They're trying to block me in. There's guys following me. They've got balaclavas on and they're trying to kill me. They're trying to ram me off the road. They've hit into the back of the car very fast. They're trying to ram us off the road. Please, I'm begging you. I'm going to die. I think I'm going to die." End quotes. Screams were then heard, and at 1:33 a.m. the call disconnected. The car left the carriageway, hit and crossed the central reservation barrier, collided with a tree and burst into flames. Saqib and Hashim died instantly from multiple injuries sustained on impact. Before the fire had taken hold, each was 21 years old at the time of his death. Investigation revealed that 2 other vehicles, an Audi TT and a Seat Leon, had been close to the Skoda at the time. The 8 defendants had all been in the cars. The Bukharis and Patel were in the Audi, which was driven by Karwan. The other appellants were in the Seat, which was being driven by Rajiv Jamal. The prosecution case at trial was, in summary, that the Audi and the Seat had engaged in a coordinated high-speed pursuit of the Skoda, which culminated in the Seat ramming it from behind and causing the crash. It was alleged that these events were events that all the defendants had agreed should happen, intending the occupants of the Skoda to be caused at least really serious harm. The background as presented by the prosecution was that for some years leading up to January of 2022, Saqib and the applicant, who was married, had been in a sexual relationship. When she ended it, Saqib was unable to accept her decision. He wanted the return of £3,000 he claimed to have spent on her. He had 3 sexually explicit videos and images of her in his possession and was blackmailing her by threatening to reveal the relationship and the images. Prompted by these matters, the applicant's daughter, Mahek Bukhari, formed a plan reflected in a message she sent on the 4th of January 2022 that read, quotes, "I'll soon get him jumped by guys and he won't know what day it is," end quotes. By early February of 2022, the defendants had all become party to an agreement that Saqib should be attacked. A plan was formed to lure him to a meeting in a Tesco car park in Leicester on the promise that he would be given his money back. 2 vehicles would be there with the 8 individuals in them. The aim was to obtain the phone and delete the photos and to give Saqib, quotes, "a good hiding," end quotes. The 2 vehicles went to the car park. 6 of the occupants in possession of face coverings in the form of balaclavas or masks. Saqib arrived with his friend Hashim, who was the owner of the Skoda. Hashim's role in these events was simply to give his friend a lift. There were calls between Mahek Bukhari and Saqib, and in the event, Saqib and Hashim drove away from the car park without stopping, realizing that they had been set up. The defendants followed in the Audi and the Seat. They were communicating with one another via a phone line between the 2 cars that remained open for 14 minutes. The prosecution invited the inference that the phones were being used to coordinate the defendants' movements in pursuit of a plan to ram the Skoda off the road, which was then executed with fatal results. A salient feature of the prosecution case was a 3-minute call from the applicant's phone to the phone of Hashim, which began at 1:24 a.m. and ended at 1:27, less than a minute before the 999 call. The prosecution case, this was a call from Mahek to Saqib of a threatening nature. To prove the case, the prosecution relied on a combination of direct and circumstantial evidence. The main strands were, firstly, the evidence of the relationship between the applicant and Saqib and messages he had sent her after the breakup. Secondly, messages between Mahek Bukhari had sent in January of 2022 that indicated a desire for retribution. Thirdly, a sequence of events compiled from call data, messages, emails, telematics, ANPR, and CCTV. Fourthly, Saqib's 999 call. Fifthly, the evidence of a forensic collision investigator. The investigator said in summary that the most likely cause of the crash was some external influence, such as a collision with another vehicle. That the cars had been travelling at speeds well beyond the limit, up to 89 miles per hour in the case of the Skoda, and 97 miles an hour in the case of the Audi. And the evidence indicated the likely collision was between the front of the Seat and the rear of the Skoda before the Skoda went out of control and hit the tree. In addition, reliance was based on DNA evidence from a forensic scientist and evidence of what was said to be weapons in the 2 cars, a wheel brace and a curved-pointed metal tool, and prison calls. None of the defendants called for help. They put forward innocent accounts which the prosecution said were concocted in an attempt to avoid responsibility. The applicant was 45 years of age at the time of the offences, having been born on the 15th of November 1976, and is now 48. Prior to these offences, she had no previous convictions. Sentence. It was common ground that for the purposes of determining the minimum term for murder under Section 321 of the Sentencing Act 2020, as the case involved the murder of 2 persons, the appropriate starting point under paragraph 3 of Schedule 21 was 30 years. The aggravating factors generic to the offenders included their failure to summon assistance for the deceased and their attempts to cover up the offences. However, although the judge considered that the deceased knew that they were going to die, quotes, and that clearly haunts their families, end quotes, this did not amount to mental or physical suffering inflicted on the victims before their death. Insofar as mitigation was concerned, the judge was not satisfied that the offenders intended to kill the deceased, as opposed to intending that they should suffer serious bodily harm. Insofar as Rajiv, Jamal and Mahek Bukhari were concerned, the judge considered that their role in the offences involved a significant degree of planning. In contrast, the judge considered that in the case of the applicant and Rekan Karwan, quotes, the degree of planning attributable to you two was significantly less than those who have gone before you, end quotes. The trial judge went on to make the following observations in relation to the applicant, quotes. Saqib Hussain, I acknowledge, was blackmailing you. He was immature and volatile, but I am quite sure that had you, Ansreen Bukhari, adopted a mature and sensible approach to ending your affair, he would have come to terms with the ending of your relationship. Hashim Ijazuddin, as everyone acknowledges, was totally innocent in all of this. All he did was agree to give his friend a lift to Leicester, and he found himself sucked into the bewildering and deadly maelstrom created by those of you in the dock. Ansreen Bukhari, you are the grown-up adult in this group, and you should have behaved like the grown-up adult, but you allowed your understandable concerns about exposure to strip yourself of any rational judgment. There were so many instances when you could have put a stop to this unfolding tragedy, but at every turn you made the wrong choice and allowed out-of-control events to escalate ever more alarmingly. Ansreen Bukhari, you are of good character, end quotes. Submissions. On behalf of the applicant, Mr. Millington, King's Counsel, to whom we are extremely grateful for the approach that he has taken to this case, points out that as a result of Mahek Bukhari's recent successful appeal against sentence, her minimum term has been reduced to a period only 1 year more than that imposed upon the applicant, despite the judge having been satisfied that in contrast to her daughter, the applicant's degree of planning was significantly less. He submits that this is a factor which ought to be borne in mind when considering whether it is in the interests of justice to grant the long extension required to enable this court to grant leave to appeal, and also when considering the length of the applicant's minimum term, in that the judge, having erroneously fixed the minimum term above 30 years, in the case of Mahek Bukhari, this may have applied an upward pressure on the length of the applicant's minimum term. Moreover, he submits that the judge failed to give sufficient or any weight to the effect upon the applicant of the background of blackmail by Saqib and other mitigating factors relating to the applicant, namely, firstly, she was not a prominent or leading member of the group. Secondly, she made no threatening calls to Saqib. Thirdly, she was not involved in any planning, nor did she make any direct threats. Fourthly, she was collected by her daughter that night from the gym. Fifthly, she provided her correct mobile phone number and PIN to the police. Sixth, she told Saqib she wanted to finish on good terms. And seventh, Mohammed Patel, a passenger in the applicant's vehicle throughout the pursuit, who was acquitted of all the offences, described the applicant in cross-examination as, quotes, mainly silent throughout the whole thing, end quotes, quotes, apart from when she started weeping, end quotes. After the crash, the applicant, quotes, had her head in her hands, end quotes. In these circumstances, Mr. Millington submits that the minimum term is manifestly excessive, and that not only should the extension be allowed and leave given, but that the appeal should be allowed and the minimum term reduced. The discussion. As Mr. Millington recognised in the course of the hearing, the reason for this court reducing the minimum term in Mahek Bukhari's case was its determination that the judge had failed to sufficiently reflect her age and level of maturity in his assessment of the minimum term. As Lord Justice Warby said at paragraph 20, after rejecting the other grounds of appeal, quotes, "We do, however, agree that this appellant's youth and her acknowledged immaturity were given far too little weight. Those factors are nowadays recognized as highly material when sentencing adults below 25 years of age. They ought to have exerted a substantial downward pressure on the minimum term in the case of the offender, an immature 22-year-old at the time of the offences," end quotes. This is self-evidently not a factor which can be prayed in aid on behalf of the applicant in this case, and as the judge rightly observed in relation to the applicant, quotes, "You are the grown-up adult in this group, and you should behave like the grown-up adult," end quotes. And therefore, there is nothing surprising about the fact that the applicant, despite being significantly less involved in the planning of these offences than her daughter, ended up with a minimum term which is only a year less than that imposed upon her daughter. It neither explains the delay in the applicant seeking leave to appeal against her sentence, nor does it afford a ground for reducing her minimum term. Moreover, we are quite satisfied that this underestimation as to the effect which Mahek Bukhari's age and maturity had upon her culpability did not apply some unjustified upward pressure on the length of the minimum term for the other accused, including the applicant. On the contrary, the judge correctly identified the appropriate starting point for the minimum term, which was not in dispute, and thereafter made an individual assessment of the aggravating and mitigating factors relating to each of those involved. However, regardless of this, we have considered the other grounds of appeal advanced on her behalf, and do so in the light of the fact that the judge, having presided over the trial, was particularly well placed to assess the factual circumstances giving rise to these offences and the effect that this had on the relative culpability of those involved. In this regard, the judge was clearly aware of the background which had given rise to these offences, namely the breakup of the relationship between the applicant and Saqib and the nature of his subsequent actions towards the applicant. However, as the judge observed, instead of resorting to violence, the applicant had many opportunities to prevent the escalation of the events leading to the death of the deceased. Moreover, as the judge also observed, quotes, "I am quite sure that had you, Ansreen Bukhari, adopted a mature and sensible approach to the ending of your affair, he would have come to terms with the ending of your relationship," end quotes. These circumstances, we are satisfied that to the extent that Saqib's actions provided any mitigation in this case, it was of limited value and had been adequately taken into account by the judge in his assessment of the minimum term. In relation to the various factors of mitigation to which it is submitted, the judge gave insufficient weight. Nearly all of these are matters which evidence the applicant's comparative lack of involvement in the planning of these offences, which the judge had already accepted was significantly less than that of either Mahek Bukhari or Ameer Jamal. Moreover, given the applicant's actions and attitude following the incident, we do not consider that the fact that the applicant may have had her head in her hands is evidence of any significant remorse on her part. conclusion. However, in the light of all the matters advanced on behalf of the applicant by Mr. Millington, we have sat back and considered whether they were overall sufficiently reflected in the applicant's minimum term. Having done so, we note that the applicant was indeed a central figure in the reason for these offences having taken place. And we are quite satisfied that the minimum term did properly take into account all the matters that have been advanced by Mr. Millington on her behalf this morning. Accordingly, refuse the application for an extension of time and for permission to appeal.
My Lords, this is an appeal against conviction.
Yes, Mr. Mann.
On behalf of Ameer Jamal,
Yes.
leave having been granted by the full court on the 24th of October last year following a renewed application for leave to appeal.
Yes.
I appear for the appellant. Mr. Bhatia, King's Counsel, appears for Mr. Gulammustafa, Ms. Akhtar, and my learned friends, Mr. Thompson, King's Counsel, and Mr. Sanaf appear for the respondent.
Yes.
As the court is aware, Mr. Jamal was acquitted of 2 counts of murder and convicted of 2 counts of manslaughter at the Leicester Crown Court on the 4th of August 2023. There is one ground of appeal, namely that the route to verdict drafted by the learned trial judge is on Judge Spencer, King's Counsel, and given to the jury during part 1 of his summing up in respect of unlawful act of manslaughter and secondary participation was wrong in law in multiple respects, thereby rendering the convictions unsafe. The key documents for today's purposes as far as the appellant is concerned.
I think it's right to say that you have permission really in relation to one ground, haven't you, which is
Yes.
the fact that the base offence, as it's known in unlawful act manslaughter, wasn't identified in the...
That's part of it. I mean, that is the central part of it as a result of the decision of the Court of Appeal in Gray. But we...
And indeed the permission given by this court.
Indeed.
Yes.
But it is... I'm not sure I'm not sure leave was provided on simply on that narrow basis. I mean, the argument that we advanced at the renewed application went beyond that point. But I take my Lord's point on that, but I think it's more fundamental than that. We say that question 8 in the route to verdict was fundamentally flawed in multiple respects. But I'll come back to that if I may. I intend to be brief today. I note this is listed for a full day. You have lengthy perfected grounds of appeal which set out the facts and submissions that I make at length.
And we have a very helpful skeleton argument from you as well.
2 skeleton arguments, and repetition will not improve them. In fact, just dealing with the point that my Lord has just raised, on one view, and I hope the court will forgive the informality, there is a slam dunk point in this case. The learned judge refused to identify for the jury the unlawful act, otherwise known as the base offence, on which the alleged manslaughter was constructed, despite both prosecution and defense counsel asking him to do so. Such a failure inevitably results, I submit, in an unsafe conviction. That is what the Court of Appeal held in Gray at paragraphs 19 to 22 and paragraphs 32 to 36, and I'll take the court to that shortly.
Well, just pausing there, they decided in that case, obviously, that there was no base offence could have been made out.
Indeed.
Yeah.
But they went further than that, and so does the compendium, with all due respect.
Well, the compendium is one thing, with respect.
I appreciate the facts of this case are different from Gray, but the principle enunciated in the judgment of Gray was quite clear and has been repeated in the compendium at chapter 19(5), paragraph 4.
But just on the compendium, it's quite a bold statement that it's automatically unsafe. Logically, the question of safety is a separate question to the question as to whether or not the legal directions were correct or not.
I appreciate that, but the language in the compendium, which clearly flows as a result of the decision of the Court of Appeal in Gray, is unequivocal. As my lords are aware, I mean, there is no ambiguity there. There's no room for an alternative viewpoint. The failure to identify the base offence.
I think the point that I was making, Mr. Menon, was this, that the compendium is one thing. One has to go back to what that is based on, and that undoubtedly is Gray.
And going further, with all due respect to the respondent, there is no answer available other than to speculate that the jury may somehow, despite the learned judge's obvious error, have convicted on a proper basis, thus rendering the convictions safe. And we say that is simply unsustainable in this case. Now, before I develop my submissions and turn to the route to verdict, I just want to briefly provide some context to what happened at the end of the evidence at the second trial before His Honour Judge Spencer, King's Counsel. There was protracted discussion about His Lordship's legal directions and the route to verdict over 3 days before the learned judge produced his fifth and final version of the document. You have that version, you have the 4 earlier versions too.
Yes.
Prosecution and defense counsel, and by defense counsel I mean counsel for the 8 defendants at the time, raised multiple concerns about various directions in all the various drafts. The learned judge was eventually persuaded about some matters, but refused to change his mind about others. Just to give one example, the learned judge was initially of the view that the defendants could be guilty of murder even if the SEAT had never come into contact with the SCOTA. It was only after all counsel, including prosecution counsel, maintained that this was untenable and wrong in law, that the learned judge was persuaded to abandon this approach and adopt what in fact I suggested to him. And you have that at page 5 of the final draft of the route to verdict. And I ask my lords to turn to that now, please.
Which page?
In fact, for completeness sake, if we could start at page 4 under the heading of manslaughter. I make it clear there's no complaint made about this at all. This is the correct statement of the law. There are 2 routes to manslaughter in this trial. A person commits manslaughter if by a deliberate and unlawful act he causes the death of another and either at the time he intended to cause some bodily harm, so the critical distinction rests upon intention, or his act was one which all sober and reasonable people, such as yourselves, would realize must subject the victim to the risk of some harm, albeit not really serious harm, being caused. In this situation, it is immaterial that the accused knew the act was unlawful or dangerous, and it is immaterial whether he intended to cause any harm. If death results, he is guilty of manslaughter. And then turning to the next page.
You say that's correct?
That is correct.
Yeah. So I just wondered why we need to look at the correct directions as opposed to the incorrect ones.
Yes, I'm just putting it in context because it took 3 days to get to this point.
That may be, but we're looking at what directions were which actually went to the jury. Yeah.
And then turning to the next page, this is the matter that I was just referring to under the heading Acts and Driving.
Yep.
This eventually was what I submitted was the correct approach. My learned friend, Mr. Thompson, agreed, and eventually the learned judge agreed. There is no doubt that the SCOTA leaving the road caused the death of Saqib, Hussain, Mohammed, Hashim, Ijazuddin. In other words, it's the SCOTA leaving the road, which is the act that ultimately needs to form the basis of any consideration of the unlawful act in respect of unlawful act manslaughter. Therefore, in this case, to prove murder, the prosecution must prove Ameer Jamal used the Leon to deliberately ram the SCOTA off the road. To prove manslaughter, the relevant acts the prosecution must prove no deliberate ramming, but the SCOTA left the road as a result of some contact from the Leon. And to prove causing death by dangerous driving, the prosecution must prove the SCOTA left the road as a result of dangerous driving by the driver of the Leon, Ameer Jamal. if the Skoda left the road simply because the driver lost control of the relevant act, driving is not proved. So that section, which first appeared in the third version of the route to verdict, is, we submit, correct in law. It simplified matters considerably for the jury. It correctly identified the act that caused death as the Skoda leaving the road. But I do stress, and this is important in terms of the questions that we eventually turned to, it was a real battle over several days to get the learned judge to agree to this. But unfortunately, he was not prepared thereafter to make the necessary changes to the route to verdict to reflect the correct approach to the charges on pages 4 and 5, despite repeated attempts by me and others, even after the learned judge produced his fifth and final version of the route to verdict. And so I now turn to that part of the legal directions, which start at page 10. And whereas my complaint is clearly about page 12, it is important in my submission to put this into context and see how the judge, we say, fell into error. So turning then to page 10, first of all, and I make it clear, there's no criticism of questions 1 and 2 in relation to the principal Rais Jamal and murder. The prosecution case was that it was Rais Jamal, the principal, who used the Seat he was driving to deliberately ram the Skoda off the road, which caused the death of the deceased. And the questions there, in respect of actus reus and mens rea in respect of murder, at questions 1 and 2, are clearly correct. The jury convicted Rais Jamal of murder and consequently must have answered yes to both those questions. However, by question 5, on the next page, I'm afraid, the judge had fallen into error. I tried on multiple occasions to persuade him to change questions 5 and 6, as did other defense counsel. I produced 4 sets of written submissions between the 20th and 25th of June 2023 and made repeated oral submissions on this point, but with all due respect, he simply would not listen. Question 5 is a question about secondary participation and the actus reus of murder. Now, given the relevant act that caused death on the prosecution case was deliberate ramming, which the jury must have found proven by now, if they were answering question 5, because it means they must have convicted Rais Jamal of murder. That question should, in my submission, have read as follows. Are we sure that the defendant, whose case we're considering, let's call him X for current purposes, intentionally assisted or encouraged Rais Jamal to use the Seat he was driving to deliberately ram the Skoda off the road? That should have been question 5. The simple and straightforward question which properly reflects unlawful act manslaughter and secondary participation as articulated by the Supreme Court in Jogi at paragraphs 89 and 90. Instead, what the learned judge did was change the goalposts completely and wrongly decide that a plan to cause death or really serious harm was the actus reus of murder for the secondary parties in this case. And it was plainly wrong. It was inconsistent with question 1, in which the learned judge had correctly identified deliberate ramming as the actus reus of murder, and it was inconsistent indeed with the judge's own legal directions at pages 4 and 5. Now, ultimately, that error did not matter in the case of Ameer Jamal, because he was acquitted of murder. He was lucky in that respect. However, others were not. 3 other secondary parties were convicted of murder, namely Ansreen Bukhari, Mahek Bukhari, and Rekhan Kawan. And of course, I don't represent them, but the fact is, in my respectful submission, that they could have been wrongly convicted of murder, even though the jury were not sure that they had intentionally assisted or encouraged the deliberate ramming, because of the focus on the plan as opposed to the ramming in question 5. And that brings me to question 8, which is at the heart of this appeal. That is the first of the learned judge's questions in respect of unlawful act manslaughter and secondary participation. Now, the court will be well aware that unlawful act manslaughter is an offence that's generated considerable case law over the years, dating back to the decision in Andrews, but of course most recently in the 2024 case of Oriel Gray. It has various elements set out in the relevant section of Archibald, and simplifying that as best as I can, it boils down to the following 3 elements. Firstly, the killing must be the result of an intentional act which is unlawful. Secondly, the unlawful act must be dangerous. And I'm not going to repeat the sober and reasonable person test. It's well known to the court. And thirdly, the mens rea of unlawful act manslaughter is the mens rea of the unlawful act, otherwise called the base offence. Now, at trial, I made a number of submissions in relation to questions 8 to 10, which I repeat again. First, the questions do not identify the unlawful act. And this is the primary point. I submitted at trial that the unlawful act could be either criminal damage or assault, and that the jury should be told so, as it was this act which caused death. Now, given the facts, criminal damage was arguably the better choice than assault. Mr. Thompson, King's counsel, also asked the learned judge to identify criminal damage as the unlawful act. The learned judge categorically refused to do so. Secondly, insofar as question 8 did implicitly identify any unlawful act that caused death, it wrongly identified the unlawful act as a plan to cause some injury to the deceased, or alternatively, a plan to expose them to an obvious risk of harm, completely contradicting his own directions at pages 4 and 5. However, as those correct directions had made perfectly clear, there had to be contact, deliberate or non-deliberate, between the Sayat and the Skoda for any defendant to be guilty of manslaughter. Even if there was a plan, that was not enough. The plan did not cause death. The plan was not the relevant unlawful act, even on the learned judge's own legal directions, to which we all eventually subscribed, including the prosecution. Thirdly, question 8 offered the jury 3 alternative routes to convict the secondary parties of manslaughter. And I submit all 3 were in fact wrong. The question reads as follows: are we sure that the defendant whose case we're considering actively participated in a joint or common plan to cause some injury to Saqib, Hussain, Mohammed, Hashim, Ijazuddin? I submit that's wrong. Or a joint or common plan to expose them to an obvious risk of harm? I submit that's wrong. Or actively and intentionally assisted or encouraged Rajiv Jamal in such a plan? I submit that's wrong. Only if the jury were sure that Ameer Jamal intentionally assisted or encouraged Rajiv Jamal to commit the base offence should they have been permitted to convict him of manslaughter, subject, of course, to their answers to the remaining questions. The base offence, whether criminal damage or assault, was caused by the Sayat deliberately or non-deliberately colliding with the Skoda. Fourthly, there is no question in the route to verdict in respect of the mens rea of the base offence. If the base offence were criminal damage, the mens rea would be either an intent to cause damage or being reckless as to damage being caused. If the base offence were assault, the mens rea would either be an intent to assault or put more elegantly perhaps, an intent to commit an assault, or being reckless as to an assault being committed. The mens rea, according to all the authorities, of the unlawful act is an essential element of unlawful act manslaughter and is missing entirely from the route to verdict. When Mr. Thompson, King's counsel, raised recklessness with the learned judge and said in no uncertain terms that the jury might wonder about reckless contact between the cars, the learned judge was, to put it as politely as possible, dismissive and refused to add a question about this. He said to Mr. Thompson that he thought reckless contact was covered in his directions, although he had not called it reckless contact. But in fact, a careful reading of the legal directions will demonstrate that neither recklessness nor reckless contact, directly or indirectly, is covered anywhere, either in the directions or in the route to verdict.
Doesn't that actually benefit the defendants? Because it's lesser, reckless is less than intent. I mean, I take your point about him not taking the point on board, but actually not a point that furthers the argument, is it?
Well, it only furthers the argument if the questions had been correctly drafted and had said that the only available mens rea was intent. But of course, the question doesn't even say that. Because, with respect, the learned judge has left 3 alternate routes to conviction as far as the actus rea is concerned, and all of them are wrong. None of them reflect the correct test as articulated by the Supreme Court in Jogi. Intentional assistance or encouragement of the unlawful act, and the unlawful act being either criminal damage or assault, not a plan.
Why, just out of interest, is not paragraph 8 capable of identifying really assault as the base offence?
It doesn't. It identifies plan. How can one read that to say that it identifies assault as the base offence? Why have 3 particulars if one would do?
So you say the middle bit, or to expose them to an obvious risk of harm, is linked to plan. That's also a plan. Because obviously the base offence could be battery, couldn't it?
Yes, battery.
That's why I don't want to say the hair running, but you said there has to be a ramming by the car. Conceptually, let's say it's a single track road with a ravine on both sides and the 2 cars are coming towards each other. You wouldn't actually, if battery was the base offence and the car comes at the other car at speed and the other driver then decides to take his chances by driving off the cliff, that would be a basis, would it not?
I entirely accept, in respect of other cases, a different approach could have been taken in respect of contact. But what happened in this trial, and I submit correctly, but even if wrongly, was that ultimately the parties all agreed to the approach at page 5, which I had offered as the simplest way through the mess. Because at that stage, we hadn't even agreed that causing death by dangerous driving was going to be added to the indictment. There was a discussion and debate about that. But I offered that as the simplest way through. Mr. Thompson agreed with me, and eventually the learned judge agreed with me. So one can't go back on that now and say, well, maybe that was wrong. Maybe there was a different approach that could have been taken. That was the approach that was taken. That was how the jury were directed by the learned judge. The clear focus was on whether there was contact, murder deliberate, manslaughter non-deliberate, no contact but dangerous driving, the road traffic offence, etc. That was how it was left. And once we went down that road, correctly I submit, the questions needed to reflect the same direction. You can't have a question that goes off on a tangent, and that's what happened here.
Why couldn't this have been simply a continuation of the planned assault, which was the whole purpose, as the prosecution were putting, of the meeting in the car park?
But that's not how the judge directed the jury.
But what I'm just trying to tease out is why wasn't it put like that, as I understand it, it was by the prosecution, effectively, that this was a continuation of what had gone on before, albeit there was some alteration in the sense that they were both in cars, and they were effectively trying to harm the person in the car that they were following.
That was the Crown's case, my lord, is absolutely right. But as a result of the legal discussions that had taken place, and the Crown agreed with this approach, the unlawful act that was ultimately was identified as a possibility here focused upon what happened on the A46 and not on any earlier plan.
Well, no,
otherwise,
you can't separate the two entirely.
how then would this one explain page 5? I mean, it clearly states on page 5, absolutely clearly states, that the act for the purposes of murder and manslaughter is the Skoda leaving the road. It's not a plan.
Why is question 9 there? Can I just ask? Because it isn't
Question 9.
9, because clearly it was felt that that should be left to the jury,
Yes.
and that's something that was clearly rejected. That rather suggests that there was an act or an event originating in the car park, and that something might have intervened between then and what finally occurred.
No, on the evidence, I entirely agree. I mean, the origins of that question are that Mr. Kane, King's Counsel, who represented Mohammed Patel, asked for an overwhelming supervening act question in respect of murder and manslaughter. And clearly, once a question like that becomes relevant, and it clearly was relevant in this case, it had to apply to all potential secondary parties in the case.
But do you see a point? There isn't really much scope for once the cars have hit each other for there to be such a thing. It makes much more sense if it's looking at the situation changing from everything in the car park.
Yes. The point that this was intended to address was that after the cars left the car park, the Tesco car park in Hamilton, and headed towards the A46, there was initially they were just driving at normal speed. And when the cars arrived at the A46 is when the high-speed chase began. And so the overwhelming supervening act on the evidence was that high-speed chase that culminated in the Skoda leaving the road.
But the way you're putting it is that the whole focus was solely on the ramming and what the consequences of that are.
I'm not saying the sole focus was. I'm saying that the focus for the purposes of unlawful act manslaughter were on the Skoda leaving the road. And the judge agreed with that, hence page 5.
Why wasn't that part of the original plan? And isn't the purpose of question 9, to take out those who may have had part of a plan, as it were, but this was a supervening event that which expunged their liability because this was not in the contemplation, or couldn't be in the contemplation of that plan.
There is a distinction, my lord, between the Crown's overall case, which is there was a plan to cause at least serious bodily harm,
Yes.
and that what happened on the A46 was a culmination of that plan, and the way in which ultimately these charges were left to the jury in respect of the act that caused death. And
Why isn't the act part of that plan originally, a continuation of it?
Because the jury were directed at page 5 that for manslaughter to be proved, there had to be a collision. That's why. There had to be a collision. No deliberate ramming, but the Skoda left the road.
What I'm trying to understand is what is there about the collision part that is not, as it were, a continuation of the plan?
If you had the whole point of giving legal directions and a route to verdict are to the jury is to simplify matters.
Well, just answering that question, why is that not part of the original plan?
Well, I'm not saying it's not part of the original plan, but the unlawful act identified for the purposes of the jury is the collision. It's not the plan. That's the act identified by the learned judge.
What happens
for the
if
jury.
that act is part of, as it were, a continuation of the original plan? In other words, it's an assault or battery committed in a different way than originally envisaged, but the jury have to be satisfied that that actually, the assault part is part of the original plan. It's just a different way it was carried out.
Even if that is right, why leave 3 alternative routes to conviction then?
Well, that's a different point altogether.
I mean, why not, even if my lord is right, and I don't accept my lord is right, because the act identified is not the plan. The Crown conceded this point. That is why we all arrived at page 5 of the directions. I mean, we can't now effectively rewrite history and say, well, the judge may have been able to take a different approach. He may have been able to articulate the plan as the unlawful act. That is not how he directed the jury. He directed the jury that the act was the collision.
But also, the jury have heard all the evidence, presumably, including how it was put throughout by the Crown as well. I mean, you can't isolate the route to verdict and the legal directions from the evidence and the way it's put, and also the way, presumably, it's put in closing. I mean, they don't, as it were, mechanistically don't have regard to the evidence as well.
When you have a route to verdict, the jury is told, these are the questions you have to answer to reach the verdicts in this case. And
well, we'll assist you to guide, it's often said to assist you to guide you to your verdict. I don't think it's necessarily said in quite such stricture.
With all due respect, that isn't the way it's put. I mean, these are provided as documents to the jury for them to literally follow in order to reach their verdict. And a defendant is entitled, in exercise of a right to a fair trial, to expect those questions to be correctly worded as a matter of law. And on no view, in my respectful submission, can question 8 be worded as being correct in law, even if the plan was the unlawful act, which of course the jury was never told in the legal directions. Even then, the question shouldn't have been this confusing muddle that it is in question 8. And of course that begs the question, where is the question in respect of mens rea? Which again is an essential requirement of a jury direction on unlawful act manslaughter.
Well, what would be the mens rea then of an assault?
Well, if the question in relation to mens rea in respect of assault should have been this, or something along these lines. Are we sure that the defendant whose case we're considering intentionally assisted or encouraged Rajiv Jamal to use the Sayat to collide with the Skoda and assault Saqib, Hussain and Mohammed Hashim Ijazuddin?
Sorry, I didn't follow that.
Use the Sayat to collide with the Skoda and assault the deceased.
So it's the magic word assault in it, as it were. It isn't.
I'm not sure why my lord says magic word. It's the base offence. If one is going with assault, which the Court of Appeal in Grey says must be identified.
What's the difference between that and actively participating in a joint or common plan to cause some injury? I mean, clearly it was unlawful injury that was being described.
Where's the...
I'm looking at your question 8, which you criticise.
Actively participated in a joint or common plan to cause some injury, yes. Or, I read in the words, a joint or common plan to expose them to an obvious risk of harm. I mean, that's an actus reus question. It's about participation in the plan.
Well, if you actively participate, it's implicit, surely, that it's intentional.
Where does it say that?
Isn't that...
Where does it say?
How do you actively participate in something unless you're intending to participate?
Sorry, the learned judge used the words actively and intentionally. He used them as different words. Where does it say in relation to either of the first two particulars that it required intentional participation? I mean, why not just simply ask the jogi question in simple language, which most trial judges are prepared to do? Why confuse the jury by offering them 3 alternatives, none of which, in my respectful submission, correctly state the legal position, all of which are inconsistent with the legal direction that the judge has already given at page 5 of his directions? I don't think I can improve on the point. I mean, if the court is against me on that point, so be it. But that's how we put it. This is a complete muddle. It was unnecessary. The learned judge wouldn't listen, not only to me, but to Mr. Thompson as well. He refused to engage with criminal damage.
Well, we understand.
He refused to engage with recklessness, and hence we're left with this situation.
But that's only stage one. I mean, obviously, you're well on your way in the right direction. But the stage two, obviously, is the safety of the convictions as well.
I understand. And so I'll come now to Gray in a minute. But I mean, before I even get there, in my submission, even without the added benefit of the Court of Appeal's judgment in Gray, looking at everything that I've submitted so far, I submit that the learned judge's approach to manslaughter in his route to verdict was wrong in law and fundamentally flawed. So, I mean, Gray obviously takes us to a different position, but I say even before you get to Gray, this is a matter that should result in the court quashing the conviction. And I say that because, one, the jury could have wrongly convicted Ameer Jamal of manslaughter, even if they were not sure that he had intentionally assisted or encouraged the principal to use the Seat to collide with the Skoda. And the importance of this is, treading into the evidence just this one time, that Ameer Jamal had said unequivocally on both occasions that he gave evidence, because our lords know that he was convicted on a retrial. On both occasions, he had said unequivocally that as soon as the high-speed chase began, he was shouting at Race Jamal from the back where he was seated, slow down, words to that effect. And he was not challenged by Mr. Thompson on that in either trial. And that's why the failure to ask the proper question in this case was so dangerous and renders the conviction unsafe. But not only could the jury have wrongly convicted him on that basis, the jury could have wrongly convicted him on the basis that of a plan to cause some injury or expose the deceased to an obvious risk of harm without there having been any collision. And the jury could have wrongly convicted him of manslaughter without any consideration of his mental state, given the absence of any question about his mental state in the route to verdict. And pulling that all together, I submit that such legal uncertainty caused by this wordy, misleading, and confused question cannot be cured, as with all due respect my learned friends suggest in their response, by some kind of impermissible speculation as to how the jury might have reached their verdict. When the learned judge provides the jury with three possible routes to conviction, you cannot possibly extrapolate from other verdicts in the case what they might have done in those circumstances. And we ask the court not to engage in that kind of exercise, which we submit be entirely speculative. But of course, Gray removes any remaining doubt, because the Court of Appeal's judgment is, we submit, unequivocal. In every case of unlawful act manslaughter now, the base offence needs to be identified, and the Crown must prove it, both actus reus and mens rea. And turning then to the case of Gray, which my lords have in the tab 3 of the short authorities bundle. I'm grateful to Mr. Samat for having produced that for the court's benefit. I wasn't intending to go over the facts of this case. I'm sure they're well known to the court. I'm going to turn, if I may, to paragraph 18, first of all, the citation from the well-known case of Kennedy number 2, and the words of Lord Bingham in the House of Lords, paragraph 7 of that judgment. To establish the crime of unlawful act manslaughter, it must be shown, amongst other things not relevant to this appeal, that the defendants committed an unlawful act, that such an unlawful act was a crime, that the defendant's unlawful act was a significant cause of the death of the deceased. Going on, a person is only guilty of manslaughter, therefore, if he or she has carried out an act that itself contravenes the criminal law. All elements of the base offence must be proved before a jury can properly find that a person is guilty of manslaughter. In my submission, that's just unequivocal. I mean, there isn't room there for some sort of interpretation or proviso type approach to a case where that failure takes place, as it has in this case. And then in paragraph 20, there's a lengthy commentary on the well-known case of Lamb, again well known to the court. And I simply point out the last 4 lines. The Court of Appeal held it was necessary to prove the mens rea for an assault as well as the actus reus. This case illustrates that it will often be helpful to consider what offence might have been charged if no death had occurred. Going on, it is common ground that the appellant could only be convicted of manslaughter if she had committed the offence of common assault, this being the only possible base offence. It is also common ground that the elements of the base offence were never specified at trial, whether by the prosecution or by the judge, nor was the failure to do so recognised by those then representing the appellant. This was not simply a failure to provide a label for a base offence about which the jury were otherwise properly directed. And we say the same thing arises in our case. The jury provided with no directions at all about any of the elements of the base offence, whether relating to the actus reus or the mens rea. They were simply not asked to consider the factual elements required to prove a common assault. This amounted to a failure to direct the jury about an essential ingredient of the offence of manslaughter. We reject Mr. Spence's admission that the judge's failure to deal with common assault made no practical difference. It cannot realistically be maintained that the jury were, notwithstanding the absence of any legal directions on common assault, aware of the elements that must be proved. I mean, I make the same point here. Nothing in the judge's legal directions or in his summary of the evidence implies that the jury was sure that the appellant committed a common assault which caused death. And then, moving on to paragraph 32 of the judgment, we discern no possible grounds for concluding that the jury could properly have been sure that Mrs. Wood apprehended immediate unlawful violence. I mean, I won't go further because these are, of course, fact-specific conclusions reached, and the facts in our case, of course, I accept are entirely different. But looking at the end of that paragraph, in our judgment, the prosecution case was insufficient even to be left to a jury. And ultimately, the appeal was allowed and the conviction was quashed. So that's, sorry.
Well, I was just going to ask you this. I mean, just leave aside the facts of our case for a moment. Up and down this country every day, the base offence often isn't identified explicitly because there's no need to do so. For example, if you've got a stabber and the person stabs the person, it's a trial for murder, the unlawful act that causes the death is stabbing the person through the heart or whatever. When you get to manslaughter, the unlawful act manslaughter at the end, all you really say to the jury was, if at the time that the unlawful act was committed, then either he intended at least some harm or all reasonable to say persons, etc. And that's what it is. You don't say, oh, actually, there's something called the base offence. What is the base offence? This is the base offence. Because you've already got the unlawful act and the causation.
Yes. Well, what you will have, though, and what you clearly will have, is the unlawful act identified in the legal directions. And so, yes, you may use the phrase unlawful act without explaining what the unlawful act is in the route to verdict.
Because it's there at the beginning. Because it's there in the beginning in the case of a stabbing, because you've already identified the deliberate unlawful act.
I would always ask for the unlawful act to be identified, because I've been in enough cases involving manslaughter being left to a jury as an alternative to murder, where confusion inevitably arises. There are always questions, in my experience, in relation to manslaughter, because it's not straightforward and it's caused so much havoc.
It depends on the type of manslaughter. If it's simply the alternative to murder in a straightforward stabbing, one doesn't need to identify the base offence.
But it will be identified. I mean, a good trial judge will always identify it, in my experience. And what is the harm in identifying
And what will the trial judge say about the base offence in that situation?
Well, let me give a real example into this.
Well, no, I mean,
Just use my example.
Yeah.
Someone stabs someone. It happened. Let's say, for example, it just nicks their leg, but therefore severs the femoral artery. They drop down dead. You start off what caused the death, the stabbing. That is a unlawful act. Then you go through self-defence if he's running self-defence or whatever, and then you get to the end, don't you? To what if you're not sure that he intended to cause at least serious harm in that situation?
Why not simply ask the question, has the secondary party intentionally assisted or encouraged the stabbing? I mean, It's so simple. It's absolutely clear. It leaves no room for any doubt. I mean, that's the question that I'd ask for in my Lord scenario. Did the secondary party intentionally assist or encourage the stabbing? I mean, that's consistent with paragraphs 89 and 90 of Jogi. The whole point of this exercise, the reason that we now give written directions to the jury, is to make it as simple as possible to avoid, if at all possible, questions coming up during their retirement. So why complicate it? But if I could deal with the broader point, I accept that you can have a situation where it is absolutely clear from the legal directions as a whole what the unlawful act is, because the learned judge has correctly stipulated what it is in the course of the legal directions before one even gets to the route to verdict. And one can then use the phrase unlawful act in the question. I'm not suggesting that conviction flowing from such a route to verdict would be unsafe, because it's clear that the jury could not possibly have reached any other conclusion than that the unlawful act was the stabbing. But how can one say that in this case, given this mess?
In question 1, the jury are asked to consider whether or not the Leon was deliberately ran the Skoda off the road. Would that assist the jury?
Yeah, so obviously Rajiv Jamal was convicted of murder. The jury therefore must have found that there was a deliberate ramming. Yes, absolutely.
And also found that there was no intervening act as well.
No, not in relation to... No, because there's no overwhelming supervening act question in relation to the principle.
No, but the secondary parties.
Yes, they would have... The 3 secondary parties who were convicted as a result of questions 5 to 7, yes, there must have been a conclusion reached that in their individual cases, there was no overwhelming supervening act.
Yeah.
But of course, the overwhelming supervening act has to be considered on a defendant-by-defendant basis. I mean, Mohammed Patel almost certainly benefited from the overwhelming supervening act question, or he may have. We don't know the basis upon which he was acquitted. Right. But he could have been acquitted on the basis of an answer to the overwhelming supervening act question. Yes, of course I accept that. And unless there's anything further on Gray, I was going to move on to the compendium. Now, I appreciate the compendium is in a statute or it is an authority of an appellate court, but it's there to assist trial judges. And Chapter 19(5), paragraph 4 is, in my submission, clear and unequivocal. Reading from the most recent version, under the heading An Unlawful Act, it is clear that a crime sometimes referred to as the base offence on which the manslaughter is constructed must be committed. It is not sufficient that a civil wrong is committed. And then this, it is vital that a base crime is identified and proved. A failure to do so will result in an unsafe conviction. All elements of the offence must be proved, and any defences that have been advanced must be disproved. The offence will usually be an offence against the person, but need not be so. And I pray that in aid. I mean, how can, on any sensible view, it be said that learned judges' questions in the route to verdict comply with this paragraph? On any sensible view.
I think the reason I bought with what you say about the sentence, it's vital the base crime is identified and proved, a failure to do so will result in an unsafe conviction, is because you yourself have just identified, if in the legal directions, the unlawful act, etc., is identified, that's not going to be a misdirection, and there isn't going to be an unsafe conviction. In other words, I think those words there are focusing on a grey-type situation where there is a need expressly to identify the base offence. Do you see what I mean? It may not make any difference for you for the purpose of your submission, but I don't read the compendium to be as black and white as that, because there will be many cases where there isn't that stark outcome, because it will be perfectly, not only perfectly safe, but perfectly properly directed because of the way the unlawful act has been identified. Do you see the point?
I do see the point. And applying that principle to this case, given that I have prayed in aid pages 4 and 5 as a correct summary of the legal position, if the question at question 8 had been as follows: are you sure that the defendant whose case you're considering intentionally assisted or encouraged the commission of the unlawful act?
You say that would have been fine.
That would be fine. Followed,
but that sort of illustrates
followed by a mens rea question.
That sort of illustrates the point what I was really putting to you, which is that when you read that bit of the compendium,
but that's not what
it isn't actually catering for the sort of wording that you've just identified, because that's perfectly.
No, I agree with that. And in fact, my lord, in the interest of full disclosure, there has been a case subsequent to Gray, which I don't know if my lords are aware of, the case of Manen, Christina Manen, M-A-N-E-N. I mean, I know about this case because I represented a co-defendant in the trial. My client was convicted of murder. Miss Manen was convicted of manslaughter before the Common Sergeant of the Central Criminal Court. Miss Manen appealed on the basis that the Common Sergeant's directions were wrong because he had not specified the unlawful act in the question, although the question was exactly as I just indicated. Has she intentionally assisted or encouraged the commission of the unlawful act? But what he had done in that case, because there were 3 potential unlawful acts, she had said that...
Have you got a citation of that?
Yes. It is... just 1 minute, please. It's 2025 EWCA Crim 1080, 1080.
And I'm assuming from what you say, it says something along the lines of what you've just said to us.
Yes, I mean, I can tell my lord what the question was. The Common Sergeant's equivalent of our question 8. It was, are we sure that Miss Manen intentionally assisted or encouraged an unlawful act involving something other than a simple and genuine purchase of cannabis and no more against Mr. Briscoe, who was the deceased, that subjected him to the risk of some physical harm? Her defense had been that she had made a phone call to facilitate a cannabis deal. The Crown said, no, you made that phone call to facilitate either an assault or a robbery. But it was crystal clear in the Common Sergeant's legal directions that the unlawful act was either an assault or a robbery. And therefore, leave wasn't even given in this case. So, of course I accept that. But that's not where we are. Our question 8 is a total mess. The Common Sergeant's question is absolutely accurate.
You've said on a number of occasions about it being a mess. We have the point, yeah.
Well, that's the point, but I mean, that's the height of the submission, Michael. I mean, I appreciate it's not pleasant to hear that, but the reality is this could have been dealt with so simply as I had asked the learned judge to do, and as 7 other defense counsel asked the learned judge to do, and as Mr. Thompson asked the judge to do, and he wouldn't listen. And, hence we're here. And in all those circumstances, my lords, we submit that this conviction, or these convictions, I should say, are unsafe.
Thank you very much, Mr. Member. Yes, Ms. Bhatia.
My Lord, on behalf of Sanaf, Gulammustafa and Natasha Akhtar, there is little that I can further add in relation to the merits that have been argued. We submit forcefully by by my learned friend Mr. Menon, King's Counsel, but I may just make the following general observations.
Yes.
Your Lordships will have had written skeleton arguments that pose through, and I would simply be repeating the same submissions, perhaps not bathed in the same golden voice, but I simply would be repeating the same submissions. So can I limit it, please, to the following three observations? And the first is this, touched upon by my learned friend, but it's long been recognised, as far back as Andrews, by Lord Atkin. Of all crimes, manslaughter appears to afford most difficulties of definition. And subsequent case law supports that assertion. I'll come back to that if I may, my lord. The second observation that I wish to make is in relation to compendium. It's plain that the forward in relation to the compendium illustrates that the objective, the overriding objective of legal directions now married with routes to verdict should be, first of all, made simple, clear, concise. They are the judicial communication between the learned judge and the jury. That's the first objective. The second objective is to make sure that they are bespoke, tailored to the facts of the case. The route to verdict effectively sets out, in essence, the relevant questions the jury must go through in a set chronology, applying the directions in law that have been given. The real concern here is the lack of a proper bridge between the directions in law which were correctly given in relation to murder and manslaughter, but the bridge which is necessary to implement those directions in law in the route to verdict. The route to verdict is a roadmap. Go to point A. Question, answer, yes. Go to point B. Answer, question, no. Go to the next question. It is a roadmap, and it is there to clarify and simplify the directions in law that are given, which can be married to the factual matrix of the case. The second point that I make in relation to that, my lord, is this. The issue with respect in relation to this particular appeal against conviction is establishing on the directions given what was the unlawful act that led to the death, tragically, of these two victims. And it is plain that through legal discussions between the bench and the bar, supported by both prosecution and defence, that the unlawful act was identified as the ramming of the Skoda by the seer. It is clear, it is concise. What was the difficulty, I asked rhetorically?
And what is that unlawful act? What is that unlawful act? I mean, you say it's unlawful, but what makes it unlawful?
It's the deliberate
Yes.
contact between two high-speed vehicles.
Yes, but what so? And, yeah.
Well, this criminal damage is one aspect of it. The
One
unlawful
aspect.
act could be criminal damage,
Yeah. What's the
Or
other?
indeed-
What's the other aspect?
or indeed assault.
Thank you. Yeah.
But the point that I make, please, my lord, is this. That identifying the base offence would have been straightforward on the factual matrix of this case. And then to raise the jogi questions would have been both clear in law, proper and right in law, and that would have allowed the jury the proper and single route to verdict. The concern and the criticism that has been raised is that question 8, formulated in the way that it is, and I don't repeat, but there are 3 different routes to verdict, must have been both complicated and difficult for the jury to be focused in relation to the jogi questions that are essential, we submit, in answering in terms of the secondary party.
Mr. Bhatia, looking at question 1 in the route to verdict, Ameer Jamal used the Leon to deliberately ram the Skoda off the road. That's the unlawful act that you've
Yes.
identified for us. So wouldn't the jury have that at the forefront of their minds when looking at the other defendants?
The deliberate act triggers, we submit, in relation to jogi and the direction which is appropriate for manslaughter. It allows them to focus on that period, and particularly the evidence that was given in relation to all 3 defendants who were not the drivers of the SEAT, in relation to evidence of slow down, stop, not challenged. And the issue that went to was that in this factual specific case, there was no opportunity to withdraw from the joint enterprise, the common purpose, because the car was travelling at 80 or 90 miles an hour.
Isn't that where
That's-
question 9 comes in?
Well, with respect, my lord, it's the focus in relation to question 8 with the jogi directions and the questions which should have been clarified and simply put in relation to question 8.
Doesn't 9 rather suggest that it's relevant to look at what happens before the moment of ramming, which rather suggests that the jury are also looking at everything from the moment you arrive at the Tesco car park?
My lord, I don't go against that observation. What I focus on, however, is the roadmap and the step-by-step. Would they have need to go to question 9 if there had been clarity and proper directions in law in relation to question 8? That's the point, really, my lord. Therefore, the criticism still falls on the structure of question 8. And furthermore, without that base offence being identified, there simply is no element of the mens rea being addressed at that particular stage, so that the jury can properly address and assess the evidence insofar as that chapter was concerned.
I mean, I'm wondering if there is a bit of a tension between question 1 and question 9, if the unlawful act is simply the ramming, because they're one and the same thing in a way.
My lord,
Whereas, if one is looking at a joint enterprise to assault in the car park, they're both understandable and reconcilable, with 9 reflecting the fact that people may not have been able to withdraw from the offence that is being contemplated.
yes, I accept that, my lord. The point that we make, however, is still in relation to the way that the trigger for the unlawful act was actually directed, namely the ramming of the Skoda by the Seat, and it all flows from that. Why not simply have, as the learned judge was invited to do both by the prosecution and by the defence, why not have clarity, precision, and correct questions as per Jogi in relation to that aspect of the route to verdict? It is an important factor which we submit because of the arguments that have been already put forward renders the conviction unsafe. My Lord, I don't believe there's further points that I can make, and I do not. Thank you.
Thank you very much indeed, Mr. Bhatia. Yes.
Thank you, my lords. At the outset, obviously, I have to concede there was no direction about the base offence, specific direction, that is. And Oriel Gray tells us that there should have been such a direction. I also concede that I did ask the learned judge to make such a direction, and he didn't. But the real question is, does that make these convictions for manslaughter unsafe? And our submission is, it does not. Because what my learned friends have focused on is the narrow moment of the ramming on the A46 as being the unlawful act, whereas the Crown case was, this was simply a culmination of an earlier plan to assault Saqib Hussain. And that plan had formed by the time everyone had assembled at the Tesco car park. And that was the way it was put to the jury. And the protection for those who were convicted was question 9. Had whatever they agreed to been rendered completely nugatory by an overwhelming supervening event, namely the driving on the A46. And my learned friends have said, of course, that the appellants gave evidence that they were shouting slow down and so forth, and it wasn't challenged. The difficulty with that submission is this: the whole basis of their evidence was challenged, that they were simply passengers in a vehicle that had happened for reasons best known to the driver, decided to embark on a pursuit. The Crown case was they're all parties to an earlier agreement. And
the learned judge made that point.
He did.
In telling the jury that if the defendants knew nothing about a plan by the time they left the Tesco car park, there is considerable force in the suggestion they couldn't do anything about what...
Yes, we cited that. That's exactly what he said to the jury, and we didn't dissent from that. But the Crown's case, obviously, which the jury had to consider, was what happened was simply a culmination of an earlier plan, which the ramming did not take out of the contemplation of the parties involved. An agreement to assault, if necessary, to get the mobile phone in the car park. And the result was that having been thwarted, the plan then continued. That was the Crown case.
What do you say about the submission that there is no direction as to the mens rea of the unlawful act?
Well, I'm not sure that's right if one looks at the question at the very beginning of this summing up, because the mens rea for manslaughter was mentioned. We relied very much on an intention
Which page are you on?
Sorry, yes.
It's just page 4.
Page 4, yeah. Where he spelt out the two ways manslaughter could occur. Two routes to manslaughter, one of which was an intention to cause some harm, not necessarily serious harm, but death resulting. That's what that direction says. And so I agree this could have been perhaps made clearer, and I'm not trying to altogether defend the way it was left, but the combination of those directions was sufficient for the jury to be alert to the need that for a conviction for manslaughter, there needed to be an intention to cause some injury, not necessarily serious, and death resulting. And if one then looks at the way the judge then framed the questions in question 8, they are aimed at the unlawful act being the agreement, if necessary, to cause some injury, in the case of the appellants, to the deceased. In the case of those convicted of murder, no doubt the jury had to be satisfied there was an intention to cause some really serious injury. But the learned judge pointed out that different people may have had different states of knowledge about what was intended. But the baseline is this. The Tesco car park, there was an agreement to carry out, the Crown say, an assault if necessary. That wasn't, as it were, the chain of causation wasn't broken on the jury's findings by the ramming off the road. And therefore, in our submission, although one looks at the ramming as the ultimate act, it was the culmination of an earlier plan. That's simply the way we put it. And we put it on the basis there was ample evidence to support that contention made by the Crown.
I mean, I wonder actually if one of the difficulties that arose was this focus on the ramming.
I'm afraid so.
Because when I heard this morning the suggestion that it could only be on the basis of the ramming, conceptually it seems to me that's not necessarily right. Now,
no.
But what obviously what is said is, well, that's the basis, the road that was gone down, to make an analogy, i.e. that once you've got the ramming, that's the problem. But it does seem to me that it may be the ramming which has caused this argument to even be available.
Well, I think, with respect, that must be right. But of course, as has been observed, if the sole focus had been on the ramming, why would one need question 9?
Can I just ask, was it being suggested that you had acceded to this, that it was necessary that the unlawful act, as it were, identified?
Well, the ultimate unlawful act, yes. But the Crown closed their case on the basis that they invited the jury to consider manslaughter on the basis of a difference in intent. So those who were convicted of murder had greater knowledge of what was going on than those who were convicted of manslaughter. That's the way we put it in closing. I agree, perhaps in retrospect, I shouldn't have been persuaded by Mr. Menon, but be that as it may, our submission is it doesn't make the convictions unsafe.
And what do you say about question 8?
Well, if one looks at it on the basis of the way the Crown put the case, it reflects the allegation that there was an earlier agreement in which there would have to be active participation by those involved.
And the early agreement to assault?
Yes, that's right. And that's no doubt why the judge...
there is criticism, well, there's a number of criticisms.
Oh, yes.
And it's suggested there's 3 different ways. Firstly, it's one of the criticisms, amongst others, is that in the first line, there's not the word intentional participation.
Yes.
What do you say about that?
Well, what the judge had done earlier in the summing up was to make it perfectly plain that mere presence at the scene when an offence was committed wasn't enough. And he said that on several occasions. So there had to be an intention to participate in something. in this case, the assault, if necessary, to get the mobile phone.
Well, you might say that both the word actively
Yes.
and the word participated both carry some connotation because they both go beyond mere presence.
Yes, they do. Yeah.
And the learned judge's directions at page 7 set that out
Yes, they do.
when he talks about secondary party joint participation.
Yes.
And it's suggested there are a whole host of, as it were, ways one can read this. I have to say, for myself, when I first read it, obviously subject to Mr. Menon's and Mr. Bhatia's submissions, that it was the active participation in a plan,
Yes.
or actively and intentionally assist or encourage
Another person.
Mr. Jamal in
Yes.
such a plan. Yeah.
Yes, that's right.
And there must be some purpose, I assume, rather than simply a mistyping that they,
Yes.
the or is between those two propositions.
Yes. I agree. I mean, there can be criticism made. It could have been clearer, but that's very far from saying that this has led to unsafe convictions. That's our submission.
Yeah.
I mean, I suppose you would say that even if you have to follow the legal directions and the route to verdict, neither the legal directions nor the route to verdict are to be read in a vacuum.
No.
Because when reading them, the jury brings to it all the knowledge of the evidence and the submissions that have been made by all concerned.
Yes, our submission is that if one looks at question 8, one has to put it in the context of the case as a whole, not just isolate it in itself. That's clear. And so far as our submissions are concerned, we set them out in detail. I don't think I can improve by going through them. But yes, there may have been a flaw in the summing up, but our answer to that is, in the circumstances of this case, unlike Oriel Gray, where there was apparently no clear base offence, here there was a clear base offence, battery, or perhaps criminal damage, but certainly battery, which was a culmination of the, we would submit, the earlier plan at the car park. That's the way
Battery or assault.
Or assault, yeah. Yeah.
It's clearly deceased on the 999 call was...
oh, he was in fear of his life, in fact.
well, of his life, but certainly of harm.
Yes.
So battery would work.
Yes.
On that scenario.
It would, yeah.
Anyway, you failed to persuade the judge to, as it were,
I failed, I'm afraid, but
read the base offence. Yeah.
anyway, those
Better
are...
identify it.
My Lords,
Yes, Mr. Menon.
just 3 brief points in response. If this court could safely conclude that the jury would have had no trouble identifying the unlawful act that they had to be satisfied had to be intentionally assisted or encouraged by the secondary party, then one at least gets some way to say that the conviction is safe. But on any reading of these legal directions, and in particular of question 8, it is impossible in my submission to reach that conclusion without engaging in impermissible speculation. Because it is the contradictions and inconsistencies between, on the one hand...
Can't we get to on question 8?
I'm saying, if the jury, reading the legal directions and the route to verdict together, and of course taking into account the fact that they had sat through the trial and had an assessment, had their own collective assessment of the evidence, if it could be safely said by this court that that jury would have had no difficulty agreeing on what the unlawful act was, unidentified by the trial judge, that had to be intentionally assisted or encouraged by a secondary party in order to secure a conviction, then I accept this court could, subject of course to other questions which I've already raised and do not repeat, start the process of reaching a conclusion that the conviction was safe. But in my submission, that's simply not a conclusion that one can reach, given the inconsistency between pages 4 and 5 on the one hand and page 12, which contains questions 8 to 10 on the other. Secondly, of course I accept that a route to verdict should not be applied mechanistically or approached mechanistically. But the reason that we have these documents now to assist juries is to ensure as best as possible that they ask the right questions before reaching verdicts. And if the questions lead them in the wrong direction, as we submit question 8 palpably does in this case, then how can the conviction be safe? And finally, when considering question 8, together with the document as a whole, the route to verdict, legal directions document as a whole, if it is possible that a jury could have convicted Ameer Jamal without being sure that he intentionally assisted or encouraged the commission of the unlawful act, which I repeat, I'm afraid, is the contact between the two cars, deliberate or non-deliberate, for the purposes of manslaughter, unless they can be sure of, unless the court can be sure that it's of that, how can the conviction be safe? If it is possible that they convicted him on a different basis because of the 3 alternatives in question 8, the conviction must, in my submission, be unsafe. Because again, the court would have to engage in impermissible speculation to rescue question 8. And that's why we say the conviction should be quashed.
Thank you very much.
Again, simply support and adopt the response to the submissions.
Thank you very much, Mr. Bhatia. Well, we're just going to rise for a few minutes to see where we're going on this. All right? Thank you very much. Gentlemen, we're going to reserve our decision in this case, and obviously we'll provide a judgment in due course. I'm sure that you'll appreciate the normal way in which this is done.
Yes.
We'll provide a draft for you to all see, which is confidential to yourselves and must not be further disseminated. To do so, as you all know, has consequences of quite a draconian nature these days. And it is for the purpose, obviously, of factual and grammatical errors. Thereafter, we will take into obviously account any submissions you make on that and affect the draft, and we will hand down the judgment electronically in court. Can I just ask this? Obviously, if the appeal is dismissed, that's one matter.
Yes.
If the appeal were to be allowed, what is the situation, Mr. Thompson, about retrial?
I would have to take instructions on that, and I shall do so in the interim, in case that eventuality is
for
met.
the time being, obviously, well, there's effectively nothing to report.
No. Well, yeah. We'll put something in writing if necessary.
All right. Obviously, subject to that. Is there anything you want to say about the trial?
No, thank you.
All right. Well, obviously, because there's remains at the present time possibility that is one of the courses we take. So there's to be no reporting of this for the time being.
Yes.
If that is still required, that will be made clear in the judgment. If it isn't, then that will also be made clear in the judgment. Thank you. Are there any other matters?
No, thank you.
Obviously, the sentence part,
Yes,
that doesn't, I think I've already said that that can be reported, but nothing to do with these 3 appeals against conviction, just for the time being. All right. Thank you. Gentlemen, thank you very much all for your assistance. Thank you.
Authorised table.